President Trump's quest to erase his criminal conviction heads to a federal appeals court today.
It's just one way he's trying to get last year's hush money verdict overturned.
A three-judge panel is set to hear arguments in Trump's long-running fight to get a New York case moved from state court to federal court, where he could then try to have that verdict thrown out on presidential immunity grounds. So he's asking the Second U.S. Circuit Court of Appeals to intervene after a lower court judge twice rejected that move. As part of the request, Trump wants the federal appeals court to seize control of the criminal case and then ultimately decide if his appeal of the verdict, which is now pending in a state appellate court.
We want to bring in our chief legal analyst, Khalif Rhodes. Khalif, when they look at these in appellate courts, they're looking for errors that the judge made. Judge Marchand was pretty accurate in what he did, but looking back at it, are there any errors you could pinpoint that say, okay, that's enough for him to win an appeal?
And those errors that they're looking at in that case that you gave, that scenario would be if I'm looking to overturn an appeal. But first, Trump is saying that I want my case to shift, to go from state court to federal court. Different track, different scenario. His appeal is still pending in state court, and he can still have every opportunity to appeal that. What he's asking for with these requests is move my case out of state court, move it to federal court where it should have been. As Andy mentioned, the judge already denied that 2 times because they stated that these are state court charges. They derived in the state of New York. The state of New York brought the charges. This has really no federal implications at all. And so the only request to go to federal court, as the judge said, was so that you can avoid dealing with this state court issue in New York. And that's why the judge denied it. So now they're asking for it again. And Alvin Bragg said exactly what I'm saying. It's a little too late. Right. I mean, at some point now, this case is over. You have already been convicted. You can't now ask after conviction to remove my case from state court to federal court because there's no case. The case is over. Judgment has been entered. You've been sentenced. I'm not sure what this legal counsel is attempting to do, but I would be extremely shocked. And I've been shocked the last couple times with rulings, but I would be overly shocked, no other way to emphasize it, if this Court of Appeals panel would allow him to move this case after judgment has been rendered to federal court, because I don't see any rationale. I don't see any precedent. I don't see any statute, any history that would allow that to happen.
If he does lose at the appeals level, any chance that they could just go all the way to the Supreme Court?
Well, then again, back to that 2-track method. If he loses this opportunity in front of this Court of Appeals for his case to be moved to federal court, right? Different appeals, so 2 different appeals happening. Then his state court appeal would be pending. He could theoretically request that the Supreme Court force a lower court to do that, but I think that would even be more surprising to me. But on the appellate level, I do think there are arguments there for appeal. I don't think it overturns the decision, but I do think there are procedural methods and rationale for appeal for at least it to be a new trial. And I can say why. If you take the Supreme Court's ruling that said that he was immune from presidential acts, there were a couple things in the trial that were presidential acts, specifically his response to statements while he was in the office. Hicks coming in and testifying to things that happened while he was in the office as well. So I think that testimony, even though and Alvin Bragg said this, I don't think that changes the outcome, but I still think procedurally those statements should not have come in based on the Supreme Court's ruling that he was immune from presidential comments or actions while in office. So if you take those out, you have another trial. I still think you land in the same situation.
And again, no real precedent for moving a case when it's already closed. What do you envision these conversations between lawyers looking like when they're trying to do this?
I mean, Alvin Bragg's already showed his hand. So if we're playing cards, we know that he's got a full house. He's ready to go and says that the law is on his side. On the other side, they're saying that the prosecution, Trump's team is saying they rushed too fast. This was selective prosecution, and they should have waited till the Supreme Court made their ruling on presidential immunity. So they're asking the court to actually do something, what we call a case of first impression. Yeah, there's no precedent for this, but we want you to make a decision and be the first court to do this.
All right. We'll see. Khalif, thank you so much.
Queen City News Plus. Just search Queen City News on your smart TV's app store.